Debt financing costs and legal agreements extend far beyond the stated interest rate. Lawyers must understand the full spectrum of cost components, the legal and regulatory boundaries governing interest rates, and the contractual provisions that determine enforceability and risk. Debt financing costs are made up of several elements beyond just the interest rate. These typically include upfront/origination fees, commitment fees, facility fees, utilization fees, administrative agent fees, legal/arrangement fees, and alternative transaction fees. Each fee is carefully documented in the loan agreement and/or a separate fee letter. To fully understand the total cost of debt, always review both the loan agreement and the fee letter, as some fees may only appear in one or the other. Practice tip: always review both the loan agreement and the fee letter to capture the full cost of debt financing. Interest rate structures and legal mechanisms. Summary: fixed rate stays the same for the loan term, offers predictability. Variable rate changes based on a benchmark, e.g. SOFR, prime rate, plus a negotiated spread. Contracts must clearly define all elements. Benchmarks and spreads. SOFR is now the main U.S. benchmark. Spread reflects credit risk and is added to the benchmark rate. Fallbacks. Contracts need fallback language for benchmark changes, e.g. LIBOR to SOFR, including possible spread adjustments to ensure fairness. Legal and regulatory framework. Usury laws. States set maximum interest rates, but these limits vary and often exempt certain lenders or loan types. National banks can use their home state's rates nationwide, bypassing stricter local laws due to federal preemption. Consumer loans face stricter caps and disclosure rules, while commercial loans often have higher or no caps. Disclosure and compliance. The Truth in Lending Act, TILA, requires clear disclosure of APR and terms for consumer loans. Noncompliance can lead to severe penalties, including voiding the loan and statutory damages. Contractual provisions and enforcement. Drafting tips: clearly specify interest rates, calculation methods, and triggers for changes. Default rates should be reasonable, usually 1 to 2% above the standard rate, to avoid being unenforceable penalties. Ambiguous terms are interpreted against the drafter. Disputes and remedies. Courts reject punitive default rates, penalty doctrine. Borrowers can challenge excessive rates and recover overpaid interest. Always include fallback provisions to protect interest rights if a rate is voided. Debt financing costs and legal agreements are multifaceted, encompassing interest rates, a variety of fees, and complex legal implications. Lawyers must ensure that all cost components are clearly defined, comply with state and federal laws, and are structured to withstand legal scrutiny. Robust drafting, awareness of regulatory limits, and careful review of all documentation are essential to protect clients and avoid costly disputes.